Thanks a lot for being here, and I'll only tell you that I'm extremely happy for this essay competition because it is, of course, because of the anniversary of UPICC, and so the speciality of the topic for us, because among the many extremely interesting instruments we have, this is one of the most popular. So we are, of course, happy for that. But I must say that the real reason why I'm happy is because I always see a lot of very interesting contribution by young scholars. And that for me is the real value added, because it means that you read them, you study them, you use them. So you are the future of the international community. And it's very nice to see that you devote your efforts in research to UPICC and to the products of UNIDROIT in general. You did a great job. Those who were prized did really a great contribution, but also all the general standard was really high. So even too much for my greetings and good luck. And I hope you will continue follow us as you did this time. Thanks a lot.
Thank you very much, Maria Chiara, for your kind words to our panelists today. I would like to pass the floor to Don Wallace from the International Law Institute, who is generally supporting the essay competition this year. The floor is yours.
Well, thank you, Caterina. I'd also like to thank Mirta and Anna and everyone else at UNIDROIT. I'm Professor Wallace. I'm chairman of the International Law Institute and also vice president of the UNIDROIT Foundation. This has been a very vigorous competition this year. I'm told by Caterina you had 117 submissions. You are the 5 who've survived. You're the winners. And I also want to thank Professor Wenhua and his student, who I imagine is that Sihui? Are you the professor's student? So I want to welcome the two of you. This competition addresses the UNIDROIT principles on the occasion of the 30th anniversary. And you look at some of the strengths of the principles, some of the weaknesses, and some of the future prospects. Just a word or two about the principles themselves, why they exist. They exist because the domestic law, which might otherwise govern a contract, is uneven in many countries. Legislations are very slow in improving that law. Conflicts of law, as we call private international law in the United States, is very questionable in terms of countries and judges being able to deal with it. And in terms of party autonomy, that of course is the key. But if the contracting parties wish to pick the law of one country, they often cannot agree which country it is. Hence, voila, we have the principles, which are unique in their value, certainly their potential value. So welcome, and I return the microphone to Caterina.
Thank you once again so much. And now it's time to move on to the panel discussion with the winners of this edition of the UNIDROIT Essay Competition dedicated to the 30 years of such an important instrument on UNIDROIT principles on international commercial contracts. And I would like just to voice the allocation of prizes between our winners. First position was taken by Anna Fonseca for her essay on the choice for UNIDROIT principles of international commercial contracts to fill the legitimacy gap in the arbitration of sustainability-related disputes. Second position was awarded to Tuğçe Bilgetekin for the stickiness of the UNIDROIT principles of international commercial contracts, a behavioral analysis. Third position was awarded to Eva Litina for the 30 years of the UNIDROIT principles of international commercial contracts, an assessment and way forward. The fourth position was taken by Ardrit Gashi on 30 years of the UNIDROIT Principles of International Commercial Contracts, the title of the essay competition. And the final fifth position was awarded to Stefan Jovanović on UNIDROIT Principles of International Commercial Contracts and New Frontiers of Blockchain, Smart Contracts, and Digital Assets. The honorable mention, as you know, was awarded to Professor Wenhua and Zhang on the assessment of the effectiveness of the UNIDROIT principles as governing law in litigation and case-based observation. And now I would like to pass the floor to Anna Veneziano, the Deputy Secretary General of the UNIDROIT, who will be kindly moderating this discussion. Anna, the floor is yours.
Thank you very much, Caterina, also for the organization of this webinar. Thank you very much, Don Wallace, for the support of your personal support in following all the steps of this competition and renewed support of the ILI. So we are grateful for your for the possibility you give to those young scholars to
reading the
present.
papers on. I read all the papers, you really.
We know you do, and you then take the final decision. So this is this is something we're very grateful for. So I was wondering, Caterina, whether you had already introduced the candidates who are actually the winners. Have you introduced their biographies already? Because I know that you have collected them, and so perhaps it would be nice to give some visibility to them in introducing them fully, and then we can start with the webinar.
I think it's a great idea. I didn't have a chance to do that yet, so let me elaborate more on our winners this time. So Ana Fonseca holds a master's of laws with specialization in international commercial arbitration from Bucerius Law School in Germany and a Bachelor of Laws from Federal University of Espírito Santo in Brazil. She is also a research assistant in international commercial arbitration and private international law and an IMI qualified mediator. Our second winner, Tuğçe Bilgetekin, graduated from Galatasaray University in 2014. She then completed her master's in 2018 at Istanbul University and is currently a PhD student at Istanbul University. She was awarded also a Fulbright PhD dissertation research grant and conducted her research at Yale Law School as a visiting researcher in 2022 and 23. Since April 2017, she's been working in the civil law department at Kadir Has University and is also a member of the Center of Tort Law at Kadir Has University. Her main research areas include contract law, tort law, property law, and the harmonization and unification of private law, behavioral law, and economics in contract law and constitutional law. Moving to the third place, to Eva Litina. Eva is a dispute resolution professional with arbitration and mediation experience. She specialized in shipping, commodities, and decarbonization. She's also a fellow of the Chartered Institute of Arbitrators and is a dual qualified attorney admitted to the Athens and New York bar. She also studied at the University of Athens, received her master's from the New York University School of Law, and completed her PhD in international maritime arbitration at the University of Aegean, where she also taught commercial and maritime law. The fourth winner, Ardrit Gashi, is an assistant professor of private law at the Faculty of Law at the University of Pristina, who is specialized in property law, contract law, and international commercial law, civil litigation and arbitration, with over 15 years of professional and academic experience. He also served as a deputy chairman of the working group for drafting the civil code at the Ministry of Justice of the Republic of Kosovo. He's also worked as a legal expert and advisor to the government of the Republic of Kosovo and various public independent agencies. Finally, Stefan Jovanović is a lecturer and PhD student at the Faculty of Law at the University of Belgrade, as you already know. He also serves as a secretary of the Belgrade Arbitration Center and conducts the research on private international law, international commercial and investment arbitration, and the regulation of digital or crypto assets. He's been recognized with several academic awards and actively contributed to numerous national and international conferences. Our honorable winners as Professor Ji Wenhua and Zhang Sui. Dr. Wenhua Ji is a professor at the School of Law, University of International Business and Economics in Beijing, China. His research encompasses international economic law, international commercial transactions, dispute resolution, and global economic governance. He published extensively on these topics in both Chinese and English. He also holds several prestigious positions, including co-chair of the WTO Chairs Program at UIBE and UNIDROIT correspondent for China and standing council member of the WTO Law Research Society of the Chinese Law Society. The postdoctoral student, Sihui Zhang, is conducting the research at the School of Law, University of International Business and Economics in Beijing, China, and she's focusing her research on international economic and trade law and specializes particularly in legal frameworks governing global trade and economic impact of trade policies. She received the National Scholarship in recognition of her academic excellence and had the honor to participate in John & Jackson Moot Court competition in 21st edition of the Moot Court as a researcher and was awarded as the best written submission complainant. That's all from my side regarding the introductions of all our winners. And I would like to let us continue with the panel discussion.
Thank you so much, Katerina. So this is to give tribute to the participants in the webinar, and it is a great pleasure for me and also an honor to moderate this session. We will follow the order, and therefore the first speaker will be Anna Fonseca. And as Katerina has already announced, her paper was on the choice of the UNIDROIT principles of international commercial contracts in filling the legitimacy gap in the arbitration of sustainability related disputes. So my question to you, Anna, is we are intrigued by the fact that you're talking about a legitimacy gap. And we're also intrigued by the fact that you are focusing on the issue of sustainability in the field of arbitration. So this makes for a very interesting combination. So Anna, can you briefly explain to us why you have chosen this title and what is your main the main points that you would like to bring to the attention of the readers? Anna, you have the floor.
Thank you very much. Thank you, everyone, for a great opportunity to be here today. As said, my topic is the choice for UNIDROIT principles of international commercial contracts to fill the legitimacy gap in the arbitration of sustainability-related disputes. Here, a short agenda. So first, I will address the first question, which is, what is exactly the legitimacy gap in investment arbitration? And of course, the applicability or the application of the UPICC to investment contracts. So first, what is the legitimacy gap, the said legitimacy gap in investment arbitration? There are specifically three main reasons for that, which are the lack of transparency, the perceived bias in favor of investors, and third, the inconsistency in awards favoring expensive interpretation of law. And for these three causes, there are two main consequences, which are the withdrawal from countries from the 1965 Washington Convention. And the second, a lot of skepticism, especially with regard to Latin American countries related to investment arbitration and, of course, foreign direct investment, countries like Venezuela, Bolivia, and Brazil. Now coming to the second part of the explanation, I would like to start speaking a little bit about the UNIDROIT and ICC initiative that started back in 2022 with a proposal from the ICC to whether adapt the existing and already successful UNIDROIT principles to investment contracts, or to create a new set of principles that would benefit from the recognition, the worldwide recognition that is already existing with regard to commercial contracts, and adapt them to be applied to investment contracts. Well, there are three main reasons why not only arbitrators, not only the civil society, scholars, and of course the parties would benefit from this choice. First being to enhance the legal certainty, transparency, and predictability that, as mentioned before, are the causes for the legitimacy gap in the investment arbitration area, which is a resistance to choose arbitration to solve such disputes. And by opting out for this UPICC or a new set of principles, parties can benefit from their endorsed reputation and harmonized application. Second, one could also agree that there could be a mitigation of risk related to post-war challenges, for example, claims that the tribunal has failed to apply the applicable law chosen by the parties. And second,
I'm sorry,
in a way,
Anna,
it could
just 1 second. There might be
Yeah.
a problem with your slides because we still see only the first one. Is this okay?
No,
We are
sorry.
not seeing the flow of the slides. So at first I thought it was an introduction, but then we understood that there was something wrong. Would you like Katerina perhaps to do it for you?
Let me try it again. It should work now.
Yes,
we see
now
it.
it works perfect.
Thank you. Thank you for the heads up. Yeah. Again, the second reason would be mitigation of risk related to post-award challenges. And for that, maybe two examples being claims from the parties that the arbitrators have not applied correctly the applicable law chosen by the parties. And second, in a way, it would also help avoid allegations of fraud and corruption with regard to awards. And finally, and for me, it's a topic very close to my heart, which is the arbitration of sustainability disputes, which tend to rise within the next years, according to current research. And also because from the side of the parties, there is a rising preoccupation, concern in add sustainability, ESG, or human rights clauses to investment contracts, and also, of course, to commercial contracts. And as we know, it's not rare to find commercial nature even in investment contracts. And for that sense, I think applying or choosing for the UPICC, or again, a new set of rules specifically to be applied to investment contracts would help the parties adapt their contracts to internationally acceptable standards with regards not only to sustainability, but again, also to human rights concerns. And that would also play a role, again, with regard to legitimacy, because one of the main criticism surrounding investment arbitration, and specifically for indirect investment, is the lack of respect to such concerns from NGOs and also the public society. And just to finalize the conversation, a good example of this investment contracts could be energy contracts and also contracts for renewable energy. Thank you so much for this opportunity, and I'm happy to continue the conversation. Thank you.
Thank you very much. No, there's something. Thank you very much, Anna, for your presentation. Perhaps since we have a little bit of more time than we thought we would have, you might be able to delve a little bit more on some of the examples that you gave, and particularly how you think that the reference to the UNIDROIT principles could be useful in apart from choosing them, generally speaking, as the governing law of the contract, but in more specific terms, what do you think could be in your view the added value of referring to the UNIDROIT principles in this type of dispute? And of course, you have already mentioned that there is a project going on. So what is your view on the sustainability issues that are now particularly discussed in both treaty arbitration, but also in commercial arbitration regarding investment?
First, I believe that the sustainability issues are very, very important. And this was something I approached also in my master thesis. I believe there is a current and rising demand from the civil society mainly, but also from business participants and also from many governments that are to add to this BITs or contracts with investment provisions or treaties with investment provisions to adequate those classic treaties to new trends, how to diminish the carbon emissions, for example, how to change the view that carbon energy is the best way, and how to enhance and foster investment in renewable energy. So I think that's quite important. And also there is current research benefiting, reinforcing this view that within the next years there will be more and more disputes on this matter, because the old treaties, they tend to not have such clauses or preoccupations, and now countries are changing their legislations to adapt to these new views, and this can maybe foster any claim with regard to expropriation of investment, and how can private investors and countries balance that. So this is something that the principles can offer a solution. And also, to the second point, I think it's also important to bring this conversation to arbitration, because in arbitration, the principles, as said in the preamble of the principles, the original version of the principles, they can also be applied to interpret the applicable substantive law. So in a sense, they can, whether it be which is not very common, but can be, depending on the substance of the new set of principles, if there is one, they can be chosen as the substantive applicable law to the merits of the dispute, but it can also help in the interpretation, and they don't have necessarily to be chosen by the parties for the second sphere. So arbitrators, I mean, the prevailing view is that arbitrators may enjoy some sort of freedom in applying soft law to arbitration. For example, to help the interpretation of the applicable law chosen by the parties. And in my essay, I offered some cases that has already happened before, and there are even new cases which I also approached in my master thesis. I hope I answered the question.
Thank you. Yes, you did, and you actually were focusing therefore more on the part of the title, the general title of the essay, which is for the future. So how can we have an application of the UNIDROIT principles with enhanced work on them, as we are doing now for the investment contract, international investment contracts project, to solve emerging issues, particularly in this area of the law. So thank you. Perhaps we will have time for second round or for a common discussion of other topics, but I would like now to move to Nuran Tuğçe Bilgetekin, and I hope I have not completely mispronounced your lovely name.
No, thank you. It was great.
So, Tuğçe, you also have an interesting title, because you are talking about the stickiness of the UNIDROIT principles of international commercial contracts, a behavioral analysis. So you are first of all, the question is, what do you mean by stickiness? And secondly, how are you actually applying the methodology of the behavioral analysis to better understand what is the actual impact of the UNIDROIT principles? Because I understand you have focused particularly on that in the current situation, and what was, of course, also in the past, with a view to the future. So you have the floor, Tuğçe.
Thank you. Can you see my presentation, first of all?
We can, yes.
Okay. So thank you for your question. I would like to begin by expressing my gratitude to UNIDROIT and the International Law Institute for giving us this opportunity. It's truly an honor to be here today. Thank you again. So regarding your question, stickiness isn't actually a legal term. It's a behavioral concept. Psychologically, parties often prefer to stick to certain rules and resist change, even when those rules are not mandatory. And this is the stickiness phenomenon, actually. So today I'll try to explain this in the light of UNIDROIT principles. So let's see where it's come from. So you see the new one, right? I changed the presentation. Can you see?
Yes, we
Yes.
can see it. Thank you.
Okay, super. So it's actually coming from the statico bias. What does it mean? As you all know, statico mean is current situation, and people see the statico as a reference point, and they want to stay in the status quo, and they don't want to change it with their decision. We call this phenomenon as statico bias, and it has an application in the contract law, which is people also see default rules as statico, and they want to stick with them rather than negotiate new terms. That's why we call them sticky default rules, despite their non-mandatory nature. So you may ask yourself, but what has to do with UNIDROIT principles, right? Because they are not a default rule. Their mechanisms are also different, because default rules works with opt-out mechanism, but the principles works with opt-in mechanism, which means that parties should expressly choose them to apply. So there is this kind of difference. So the problem is to answer here, can we apply the stickiness to opt-in mechanism? And the answer is yes. With the standard form contracts, we know that parties also see them as a reference point, and those contracts become sticky. However, there is one major difference. At least one party should present it at the beginning of negotiation as a guide for them to be sticky, which is not a requirement actually for the default rules. So now if I have to analyze the UNIDROIT principles, they are not a standard form contract nor a default rule. They are somewhere in between, we can say, because it's possible way of usage. For example, as an applicable law, it's more similar to default rules. However, as a guide for negotiation, it is more similar to a standard form of contract. So we have to see with its different way of usage. As an applicable law, we know from surveys that it has a low usage. But the reason behind it is not about, I think, its stickiness, because it's about a validity concern regarding the choice of law. So we don't have, I think, enough data to determine whether or not the principles are sticky as an applicable law because of this validity concern. However, we have a good survey that shows us that there's a good level of usage by the parties of the principles as a guide for negotiations. But as I told you, those are more similar. This way of application, I think, is more similar to the standard form of contract. By the way, what I mean by as a guide for negotiation, parties take the principles and they look at the provision and try to draft their contract according to those principles, right? What I mean by the guide for negotiation is that. So since it is more similar to the role of the standard form of contract, I believe that in order to gain the stickiness effect, as was it the same with the standard form of contract, it should be proposed at least by one party at the beginning of negotiation. This one is key. The timing is key here, because otherwise, if it's not proposed by one party at the beginning of negotiation, we won't have this stickiness effect, and this will always also create a bargaining advantage for that party. Also, you may ask, but why is it important to have some stickiness with its role as guide for negotiation? Because as I already told, it has low usage as applicable law, so it will increase the impact of the principles in real life. Also, a second more important advantage, I guess, it can pave the way for its application as an applicable law. And I have a great example here. It's Lemire versus Ukraine case. It's an exit case. Here, parties were not able to choose an applicable law. And what they did, they incorporated extensive part of the UNIDROIT principles into their settlement agreement. So they used the principles as a guide for negotiation, and they took them and incorporate them directly into their contract. So what happened next? The tribunal chose the applicable law. They say it's international law, but within this to have particular regard to the UNIDROIT principle. So what happened? What started as a guide for negotiation became as an applicable law. So I think it's important. Here I'll give two policy recommendations. Actually, I have more, but since because of my time limit, I'll only give the two of them. My first policy recommendation to increase the already existing stickiness of the principles is to add the sentence, they may serve as a guide for drafting contracts, into the preamble. Because in its current version, it's not in the preamble, but it's in the comment of the preamble under the heading 8, other possible usage. But I don't think it's enough to catch attention because, in order to have the stickiness effect, one party should propose it at the beginning of the negotiation. If the lawyers don't know this option, they cannot propose it. Therefore, we have to catch their attention. And that's why I propose it to add into the preamble. And as for its location, I propose it to add just after the applicable law options, because as I told you, it can pave the way for its application as an applicable law. So I think it's important. Secondly, my second recommendation, I changed the comment of the preamble accordingly. So I add a new paragraph here, and I speak about how we can use the principles as a means of guiding the drafting contract. Here, I talk about the principle may be used as a guide at the beginning of negotiation. I purposely add this part, because otherwise we won't have the stickiness effect. Here I am trying to nudge party a little bit to use it when they have some concerns about to use which as an applicable law. You can still use it as a guide for drafting because of its fair, balance, and neutral framework. And last but not least, here I talk about parties are advised to use the same wording of the articles of the principles and directly integrate the principle as whole or partially into the contract as much as possible, just because I want to make to facilitate for the arbitral tribunals and the courts to, from that, as it was in the Lemire versus Ukraine case, to use it as an applicable law, or if they already chose an applicable law, the court can still use it for implementation or interpretation or supplementation of the domestic law. So I think it's important. In the essay, I also talk about the stickiness for legislator, but here I don't have time for that. But if you have any question about it, I'm happy to answer. So thank you very much for listening.
Thank you very much. Thank you very much for this very interesting presentation, and for referring to different uses of the UNIDROIT principles and how they can actually affect parties' agreement in a way. So I would have a couple of questions for you, but I think in all fairness, we might decide if Katerina also agrees that we might open a short round of questions now for those first two presentations, and then of course we will open it also for the other three presentations, and for the finally for the honorable mention paper. So since I have the privilege of having the floor, I will abuse it and put the first question. And I had already put actually surreptitiously a question to Anna before, so now I'm putting the question to Tuğçe, which is you talk about it is very the UNIDROIT principle. One part.
I have a connection problem. Can you repeat the question?
So I had just started.
Okay.
Right. So because I think it's our
probably.
Can you hear me now?
Yeah, it's better. I can.
Right. Okay. Just let me know. Okay. So I can question. So refer to that the one of the parties that principles.
I think we have problem.
So let me try to speak best solution, but perhaps my voice better. Is it still problematic?
I think it's a bit
better. It's a bit better.
Okay,
yes.
So you will just see my name.
Yes.
And I will put the questions. Again, the fact that in order for to call it of the UNIDROIT to actually have its full effect, one of the parties, the UNIDROIT principle, the basis to conduct negotiations at the beginning of the negotiations, if I understood well. So why wouldn't it have the same effect if this reference to the UNIDROIT principles is done at a later stage of the negotiations, exactly because you would like to negotiate an effective contract, but you may have different positions and different opinions, and then you come to the conclusion that a neutral international solution for certain issues, because if you look at the incorporation of the UNIDROIT principles in the contract, then you would probably not look at them as a whole, even if you say that that is the right approach, but you would probably try to solve the specific issues that you might wish to solve in the contract. So why wouldn't it have the same impact if you refer to it later in the negotiations? Also because this is what might happen if you have a mediator or an arbitrator and there is a dispute, and in order to find a mediated solution in that context, it could be the arbitrator itself who decides to propose this solution to the parties. Thank you.
Thank you for the question. Actually, it happens, but it's a different kind of agreement by then. It's more like a settlement agreement when it's proposed by arbitral tribunal. But what I mean by at the beginning of negotiation, let's say parties have a sales contract and they want to choose some provision for their contract. The decision-making process works with reference points. And what we see as reference point is the status quo, the current situation. So if I have a template in the beginning of a negotiation, I will see that template as a reference point. So I don't want to change my decision afterwards. But let's say I start with UNIDROIT principles. So I see that template as my status quo, and I'll choose it as a status quo. And if they don't choose UNIDROIT, that means they choose something else, because we don't start to write our contracts from the scratch in general, right? We already have some templates. So if parties have already started with another template, that means that template will have this status quo effect. So it will be hard for the other party to propose at a later stage the UNIDROIT principles, because parties won't take them anymore as a status quo. But when we start to the disputes process, that means that we enter into the new phase. So it's also a beginning phase. So since it's beginning, parties are more open to choose something else as a status quo. But I don't believe that if the arbitral tribunal doesn't propose it at the beginning of the tribunal, I don't think parties will take into consideration in a later phase. But maybe with an exception, let's say something important in the contract, which is not related to other templates, we can only prove it in the UNIDROIT principles. In that case, since there is no other example in other template about the specific provision, UNIDROIT principles can act as a status quo because it's something new we haven't discussed yet, so it might be a template. But if there's already a provision similar in another template which was proposed before the UNIDROIT principles, what we know from the stickiness, parties won't consider it because they don't want to change the current situation. I don't know if it was clear enough or not.
Thank you very much.
Can I ask a question?
Of course, Don. And please, can you keep your answer short, however, because we want to give also the other
very quick.
Not you, Don. Not
Sorry.
the question, the answer.
It's the same question. I'm not a behavioral scientist. Tuğçe Hanım, is there any empirical evidence of any cases? Because in effect, what you're saying is the principles would be like a standard contract and they'd stick. Are there any examples you can give us?
Other than UNIDROIT principles?
Yeah, where the UNIDROIT principles acted as the template you've suggested and stuck.
Yeah, it was, for example, the Lemire versus Ukraine case, which was an exit case. It happens like that. Or, for example, other than UNIDROIT, we can give the example of FIDIC contracts. For example, even the World Bank use it as their template.
I understand the FIDIC, and I'm saying, do you have any, not legal case, any factual evidence where someone introduced the principles at the beginning as a template and it worked? That's what I'm asking.
Yeah, as a case, I know only the Lemire versus Ukraine case, but we have some surveys, and in those surveys, parties, it was like country-based surveys, and in those surveys, we saw that, yes, parties are aware of this option and they are using it. We know just from surveys. That's it.
Thank you very much.
Thank you.
Any other questions at this point for the two first presenters? So if I don't see any, so we can continue with the presentations, and very pleased to introduce Eva Litina, who will speak about the 30 years of the UPICC an assessment and way forward. So what is, in your opinion, the way forward, and does it derive from the assessment that you made of how the UNIDROIT principles have been used or have been useful until now? You have the floor, Eva. Thank you.
Thank you very much for the kind introduction, Professor Veneziano. Can you see my presentation?
We can
Yes,
see
we
it,
can.
yes.
Thank you.
Perfect. It is a great pleasure to give this synopsis of my essay, and I would like to thank the UNIDROIT, the International Law Institute, and the UNIDROIT Foundation for organizing this essay competition, this webinar, and for awarding me this prize. The topic of my presentation is, of course, 30 years of UNIDROIT principles of international commercial contracts, and more specifically an assessment and way forward, and I believe I will be able to answer to Professor Veneziano's question throughout my presentation. So the structure of the presentation is the following. First, we will discuss the application of the UNIDROIT principles in contract drafting and dispute settlement. Then we will briefly discuss the influence of the UNIDROIT principles on domestic laws and international law instruments, and the presentation will close with the role in new frontiers of contract law and some concluding remarks. The first and most obvious use of the UNIDROIT principles in practice is when the parties choose them by incorporating them into their contracts. The standard form contracts typically include a model clause or a selection of the UNIDROIT principles. They are a common feature in commercial relationships because they reduce transaction costs and they promote certainty, predictability, and uniformity. Typically contain a choice of law and choice of forum where disputes will be adjudicated. There are no global statistics on the actual use of the UNIDROIT principles in international contracts and dispute resolution practice, and obviously it is hard to provide precise data. The information we do have available are court decision and arbitral awards referring to the UNIDROIT principles and the collection of cases available at the UNILEX database. From this data, according to this data, the UNIDROIT principles have been recognized over time. Of course, this data is not reliable, as it is impossible to estimate the actual number of arbitral awards, given that most of them are confidential and remain unpublished. In fact, it is determined that the parties rarely choose the UNIDROIT principles as applicable law in their contracts. From a practical standpoint, confirmed with those negotiating contracts, the choice of law and dispute resolution clause is one of the last and quickest points to be considered. Tuğçe has already explained the stickiness effect in standard form contracts. Another further explanation for avoiding the UNIDROIT principles is the lack of predictability and certainty. Let's now briefly turn to the influence on domestic laws and international law instruments. I will be very brief on this. Perhaps the most crucial function comes indirectly through the influence of the UNIDROIT principles in the interpretation and application of national law and international law instruments such as the CISG. The interface between English law and the UNIDROIT principles merits some further consideration, given that it is most frequently selected in standard for contracts. And for this reason, I mention it specifically in my essay. Sector-specific standard contracts, such as maritime and commodities, often choose English law, English courts, or London arbitration, regardless of where the parties have their places of business. The UK Supreme Court has characterized the UNIDROIT principles as widely used codes and as influential attempts to codify the law of contracts internationally. And now let's turn to some future perspectives, the way forward. Contracts arising from the Chinese Belt and Road Initiative and emerging contracts relating to blockchains, cryptocurrencies, and metaverse are promising future fields of application for the UNIDROIT principles. I believe Stefan's essay will enlighten us on this further. What I would like to highlight is that unlike an international treaty, the UNIDROIT principles are flexible. So a crucial question is whether it would be desirable to elevate the status of the UNIDROIT principles to a binding instrument. However, the experience of drafting, negotiation, and ratification of international conventions confirms the difficulties. On the other hand, self-regulation via standard contracts is both successful and efficient. So instead, the UNIDROIT principles could serve as a useful guide during the negotiation of standard for contracts, as Tuğçe mentioned, and in interpretation and gap filling of the applicable national laws. Another idea is adopting the UNIDROIT principles as a model law. But again, in this case, such future work should avoid overlap with existing instruments. By their nature, the UNIDROIT principles are particularly well suited to serve as a background law in applying domestic laws in an international context. Such development of the UNIDROIT principles to a background law can receive a significant push by the parties if they expressly agree that the domestic law chosen in their contract shall be interpreted by the UNIDROIT principles. And this brings me to some concluding remarks. Undoubtedly, the UNIDROIT principles will continue to play an important role in negotiating and drafting cross-border contracts. And apart from cases of direct application, the UNIDROIT principles also indirectly influence the interpretation and application of the applicable law. They can also be used as a checklist when drafting international commercial contracts and as a model for future legislation. Easily accessible, they contribute to the availability of information on the contents of rules. And I believe that UNIDROIT should continue its efforts to increase the available information and knowledge on the UNIDROIT principles. Thank you very much for your attention.
Thank you very much, Eva. So here again, I think we might put some questions at the end of the 3 presentations. So allow me to give the floor immediately to Ardrit Gashi. I understand that you are not showing a slides. Is this correct? And so you do have a very general title too, because it's the title of the essay competition, 30 years of the UNIDROIT Principles of International Commercial Contracts. You address several questions in your paper, and so I would like to start with a very specific one, because you do spend some time in addressing the impact that the specific language used by the UNIDROIT principles has in their success or in their usefulness. And therefore, could you elaborate a little bit on that, and then perhaps address from that specific topic the other issues that some of the other issues that you have treated in your essay? Thank you.
Thank you very much. Dear colleagues and esteemed participants, I would like to deeply thank you for organizing this important conference. Usually, anniversaries of significant events spark curiosity, debate, and special reflection on those events. Such was the case with the 30th anniversary of the UNIDROIT Principles of International Commercial Contracts. Maybe in my title of essay is missing also one subtitle, that is reflections on the past and recommendations for the future. But it's not your fault, it's my fault, because I do not present in the essay. However, my essay is based on 3 pillars. First, it revolves around presenting a compelling argument centered on fostering deep cooperation and engagement with businesses, community, and pertinent stakeholders, because they play a crucial role in shaping and the landscape of international commercial contracts. The practical experience and insights into the market dynamics, trade practices, and contractual negotiations provide valuable input for the analysis and understanding the contract law. In this regard, UNIDROIT should continue the excellent and useful practice of extending cooperation not only with legal institutions and schools of law, but also with economic chambers, because economic chambers provide direct access to businesses and serve as important hubs for business, providing resources, networking opportunities, support service, etc., etc. But why did I give importance to this component in my essay? This is because I argue that the drafting process of the contract is completely a private lawmaking, and businesses are ones that draft the contracts. As well as, the most important at this point is that we are not confronting with the private international law and its restrictive rules. If, for example, from the inception of their contractual engagement through negotiations, contractual definitions, the parties demonstrate a consistent incorporation of the UNIDROIT principles, they may contribute largely overcoming of these challenges before the judges and arbitrators. Indeed, these facts will essentially dictate the entire process of the contractual relation in one hand, and also the court proceedings in general. Secondly, in the other hand, the essay points out some benefits for businesses if they use UNIDROIT principles. Because experience demonstrates that ensuring clarity throughout the entirety of the contract presents a significant challenges, especially when parties come from different legal systems and nations. Therefore, to overcome these differences, the UNIDROIT principles play a crucial role in providing the simplicity, the flexibility for the businesses and the parties, based on the language and content of the UNIDROIT principles, as well as extensive legal commentaries. It becomes evident that no domestic law specific country can establish such a legal frame of a reliable maximal standards upon which businesses from different countries and international trade can rely in their activities equally. And third, the essay analyzes and provides for the potential application of these principles as a soft law in jurisdictions where the private international law rules as a hard law challenge their application. And in this context, I have used an argumentum ad contrario that can be made, exemplified by the CISG. For example, CISG is a convention and represents a hard law instrument designed for the international sales of goods. It is legally binding on the parties, judges, and arbitrators when the conditions outlined in the instrument itself are satisfied. However, based on the principle of party autonomy of the will, parties retain the ability to exclude its application from their contractual relations. And in this context, the essay aims to open a debate within the international legal community regarding the reconsideration of the rules of private international law towards strengthening the principle of the party autonomy in the contractual relations. But in the end, above all, in my essay, it underscores the imperative call for the application of a bottom-up approach from the UNIDROIT through direct collaboration with businesses actors. These actors serve as a primary catalyst for the application, for the progression, and for the modernization of the law. I think that as for UNIDROIT principles, we can say just they possess plenty of credentials to be regarded as international business law, focused on the contracts, and they are an opinion juris masterpiece. So, but the character of the soft law should serve just a stage towards the adoption of the binding rules in the future.
Thank you. Thank you very much, Ardrit. So if I understand well, you are a bit skeptical of the effect of soft law in the long run. I mean, it does have some usefulness, and especially when parties draft their agreement or they use it in a private way. But then in the long run, in your opinion, what remains is the rules that are then applied as binding rules by courts. So this is of course up to discussion, but I would like to now give the floor to the last of the winners, who is Stefan Jovanović, and his title has already been introduced by Katerina. He will speak about the UNIDROIT principles of international commercial contract and the new frontiers of blockchain, smart contracts, and digital assets. So the question I would like to pose to him to start the conversation is how do you see the UNIDROIT principles being connected to these new frontiers created by the emerging technologies, of course, smart contracts, but also in relation to, for example, blockchain and digital assets, because those are different. They are not on the same level. They are different issues that are treated in your title. So you have the floor. Stefan.
Thank you, Professor Veneziano, for an introduction and for a question to kick off my presentation. Thank you also to Eva for slightly introducing my topic as well in her presentation. So maybe I can answer on this question because I think that UNIDROIT itself actually recognized the importance of digital assets, because as we all know, the UNIDROIT in May 2023 adopted principles on digital assets and private law. Of course, that document is not dealing with all aspects that I'm dealing in a paper, but we can, from this UNIDROIT action, actually see that UNIDROIT itself recognized the blockchain era, recognized the new technologies as something which can change the business per se, but also contracting and possibly international commercial contracts as well. Those principles are not important just as guidance for the digital assets and private law that can have some impact on the other UNIDROIT instruments as well, but also they contain several definitions which are important for my paper. I will very briefly actually explain those three concepts in a sentence. Blockchain is a distributed ledger technology ensuring transparency, security, and immutability in recording transactions. So the technology itself is different than any other that we had before that technology. On the basis of that technology, smart contracts have arisen as well. And in a sentence, they are self-executing contracts. UK Law Commission actually said legally binding contracts, which are directly written into code, and they actually are used for automating the enforcement of agreements. There are different types of them, and you can see three main types on the screen as well. Digital assets represent assets which are existing in digital form, or as UNIDROIT explained in their principles on digital assets and private law, they include electronic records, but only if they are capable of being subject to exclusive control. So the UNIDROIT is actually focusing on proprietary issues, and they seek for exclusive control in order to assets to be qualified as digital assets. But the aim of my paper is actually to analyze the intersection between the UPICC and blockchain, smart contracts, and digital assets. And in this part of my essay, I actually have recognized the usefulness of the UPICC in those three concepts. First is that UNIDROIT principles global applicability actually makes it a perfect fit for a borderless Web3 environment. What I think about when I'm talking about Web3, I think of Web3 as a word that can encompass actually blockchain, smart contracts, and digital assets, because they are the backbones of the Web3 environment, which is a system that is globalized, borderless, and also decentralized. Unlike some contracts tied to specific national laws, the UPICC enables businesses to operate seamlessly across jurisdictions. Why? This also have result on that the UPICC enables startups to significantly reduce legal costs by allowing them to reuse contracts globally without the need for jurisdiction-specific legal advisors. Because in the Web3 sector, let's say, because in my opinion, industry is a wrong word, many companies are actually startups that depends on internal writing, so they don't have enough funds to engage sophisticated lawyers in every jurisdictions they have transactions. Also, as Eva said, unlike international conventions, the UPICC are sufficiently flexible and they can actually allow to adopt to new circumstances and support the development of a modern lex mercatoria in the crypto field, which is now referred to as lex cryptographia. And one of my conclusions is that actually UPICC, despite the challenges we will hear in a few moments, can form the new lex mercatoria, which is, as I said, now lex cryptographia. For activities involving smart contracts and digital assets, the UNIDROIT principles combined with an arbitration clause. So I, in essay, explain why it's important to be combined with arbitration clause, provide an ideal framework for contracts involving blockchain, smart contracts, and digital assets, because mainly the UPICC addresses key goals of the Web3 industry, such as decentralization, in the sense that they are not tied with any jurisdiction specifically, efficiency, predictability, and certainty. Despite that part, the intersection part, which is which show advantages of the UPICC, this does not mean that challenges do not exist. Firstly, blockchain operates under the principle of code is law, creating a tension with traditional legal frameworks, laws, and rules like the UNIDROIT principles. Because in the Web3 sector, users want to avoid national laws, national courts, etc. So we will see whether the UPICC can be relevant in that so-called blockchain legal order, which is also depending on blockchain arbitrations, which are not anything like traditional arbitration we know. But in my opinion, there is also the advantage of UPICC, because the strict nature of smart contracts can lead to unfair outcomes. And the UNIDROIT principles addresses this by providing many principles, like principle of good faith, reasonableness, fair dealing, gross disparity clause, etc. So this means that UNIDROIT principles offer tools to mitigate such issues. The second challenge I recognize many of them, but now I'm just referring to 3 of them. The second one is the abundance of mandatory rules concerning the digital assets. So it can be problematic for UNIDROIT principles, because nowadays different jurisdictions have different approaches to digital assets, especially cryptocurrencies, some of them being friendly, some of them being hostile, some of them somewhere in the between. And this can actually impact and complicate the UNIDROIT principles application. The third one that I recognize is AI-driven smart contracting. Even though I recognize some challenges, I think that as AI becomes increasingly involved in drafting, maybe in executing contracts as well, the UNIDROIT principles' adoptable nature will remain crucial for addressing potential error or disparities arising from the AI-driven smart contracts and contracting per se. To conclude briefly, despite these challenges, in my opinion, the UNIDROIT principles stand as a valuable and relevant instrument. Its adaptability and universality position them to play a significant role in the evolving lex mercatoria in the blockchain era. As we celebrate 30 years of the UNIDROIT principles, it is evident that their clauses are as vital today as they were 30 decades ago. And I hope even more so in the face of rapidly emerging technologies. Thank you for your attention, and I'm looking forward to our discussion.
Thank you very much, Stefan, for your presentation, and thank you everyone for keeping in a very reasonable time frame when presenting. I think that now, if Katerina agrees, we could open up a short round of questions on these three presentations, or if you still have curiosity on the other two, of course we will not stop questions on the other two as well, or comments, but perhaps concentrating on the three later speakers. And Katerina, I don't know if anyone around this room of speakers would like to pose a question or make a comment on those three essays.
At the moment, I don't see the hands raised from the audience.
Okay, and neither in the chat, if there are questions in the chat, because I can't
in the
see.
chat. Yes, we have a question from Tomasz Tomczak. Question to Dr. Eva Litina. Do you think that the deglobalization is a problem for the UPICC application in the future? And another question goes to Stefan Jovanović. Who, in your opinion, then should solve the dispute in the Web3 environment? I think these are two very thought-provoking questions. Thank you, Tomasz. And should we then give the floor to the panelists?
I think it is a very good idea. So perhaps starting with Eva. Please be short.
Thank you. This is indeed a very interesting question, and the topics of the globalization and the standardization of contracts. It is. I briefly mentioned this in my paper as well. The interplay of the procedures in international organizations versus the parties preferring national laws so that they are more certain about their application. As to the UNIDROIT principles, I don't believe that the globalization would be a problem, because we already suggest that the UNIDROIT principles are particularly well suited to serve as a means of interpretation or supplementing national law. So I don't believe that the globalization should be an issue.
I'm sorry, Eva, I'm sorry. I think that probably because you didn't see the written question, you might have misheard what the question was. It was actually the opposite. So the trend towards globalization. So the trend towards localization, so would this, in your opinion, be something that would perhaps diminish the usefulness of the UNIDROIT principle? If I understand well the question that was posed in the chat. Thank you.
Yes, I don't believe that deglobalization would be a problem, because it is indeed the UNIDROIT principles are indeed very well suited to serve as a means of supplementing or interpreting national laws. So even when the parties choose a national law, which is most frequently the case, they can also choose the UNIDROIT principles to supplement this specific applicable law. So even in terms of the globalization and these competing forces of international conventions versus national laws, I believe that the UNIDROIT principles can serve very well in international commercial contracts.
Thank you,
Anna?
Eva.
Anna, can I ask a
Yeah.
question?
John, yes, we still have a pending question, but I will. I think let's hear your question first,
Well,
Don.
it's the same point. Maybe it's not a question. I mean, what does deglobalization mean? What does localization mean? Maybe it's happening in the economy, maybe not. Maybe all the more reason for a universal approach in terms of contract. So I don't see why. I think almost just the opposite sort of imperative coming from that.
Thank you, Don. So you're saying in a way that even if there might be trends towards shying away from globalization, as it was seen in the recent past, the usefulness of the UNIDROIT principles as a means to introduce global language and also the possibility to continue to use uniform and common rules is on the opposite, enhanced, even if instead of being diminished, if I understand well what you have said. Okay, thank you, Don. So that was complementing very well the question and answer that we heard before. And Stefan, you also received a question. So Katerina, do you remember it?
Yes,
Because
yes.
you're young, you have a good memory, so please answer the question.
Yes, so the question was who should solve the dispute in the Web3 environment? And it is like very interesting question, because there are opinions that Web3 disputes should be resolved throughout blockchain arbitrations. Blockchain arbitrations are certain platforms which do not have actually so many commons to traditional arbitrations. And even the New York Convention applicabilities put it into question. And in my other paper, which is not in my essay, I actually analyzed and came to the conclusion that blockchain arbitrations are suitable for the binary disputes. So the disputes that are very of small value and small complexities. And in my opinion, if the Web3 environment produces like the large disputes, very complex disputes, then the blockchain arbitrations would not be suitable solutions for those kind of disputes. We will rely on the traditional arbitration system, but also that does not mean that traditional arbitration should not adopt to those new challenges. Traditional arbitration as well showed previously as very agile to the new industries. And in my opinion, the traditional arbitration has to be agile in this new context as well. So the answer very shortly is that for the small binary disputes that are not complex, blockchain arbitration can be a very suitable mechanism. But if the complexity increase and also the value of the disputes, traditional arbitration should take the stage again.
Thank you. Thank you very much.
Anna, I see we got one more question for Stefan.
We have Professor Christoph Paulus, who is putting one question on the web. And the question is again to Stefan, what is the contract in your smart contracts? Is it not just a when-then thing? So why are we talking about contracts, and why are they, therefore, I understand the UNIDROIT principles may play a role as, a legal framework. Thank you.
Thank you. This is also a very interesting question, because there is tremendous discussion on enforceability of smart contracts, whether they are contract per se or not. But now I will refer to my presentation and the 3 types of smart contracts that I actually put there, where we can actually divide smart contracts on traditional paper contracts with automatic execution throughout computer code. So in those contracts, just some part or every contractual obligation is put into system and will be executed automatically. The second part is a hybrid contract, which means that we have traditional agreement, we have almost the whole contract into the code transformed, but some clauses like governing law and applicable law and jurisdiction of the court of the tribunal is put into the traditional paper contract. And the third part is a contract drawn up exclusively on computer code. For example, as I mentioned, UK Law Commission focused on the second part, so on hybrid contract, and they said that they are legally binding contract that actually allows automatic execution. So we can, of course, have discussion whether they are legally binding or not. But if we say that contracts can be concluded in any form and that we have meeting of the minds, in very flexible approach, we can say that smart contracts can actually be like legally binding and enforceable contracts. I hope that it answers slightly on your question.
Thank you. It was Professor Christopaulus' question. So hopefully he's happy with it, but if not, we can engage in a conversation with him, perhaps if we have more time later. So Katerina, are there any other questions on the web? I don't see any. Perhaps you do.
Me neither. I think we
Okay.
could
So
proceed.
any other questions around this virtual table? If not, I would like then to give directly the floor to the honorable mention paper we have already announced. This is a paper co-authored by Professor Wenhua Ji and Miss Sihui Zhang. I hope I have pronounced your name well. And the topic of their paper is an assessment of the effectiveness of the UNIDROIT principles as governing law in litigation, with a subtitle Case-Based Observation. So I would like to leave them the opportunity to decide how to divide the presentation, and perhaps if we have time afterwards, as we hope, we might have a general round of questions involving also this presentation. So perhaps I saw that Professor G. Wenhua, you have already opened your mic, so I take it that you will start speaking. So I will give you the floor. Thank you.
Thank you very much. And first, I would like to thank the UNIDROIT and the International Law Institute for this opportunity to present our paper. Indeed, we are very pleased to receive the honorable mention. I understand that this is a great encouragement to me and to my student. As we all know that the UPICC is a very important international legal instrument. It makes a positive contribution to the development of international rules on commercial contracts. It also has a strong reference value for China's contract law legislation. I recently just published a short essay on with respect to this issue in the Uniform Law Review. And I will continue to instruct my students to conduct their research on UPICC related issues. And now I would like to hand the floor over to my student, Sihui Zhang. And she recently completed her internship at the UNIDROIT, and thank you again. So, but I encourage Sihui Zhang to keep it as brief as possible, because we are running a little bit out of time. Thank you.
Thank you very much. So, Sihui Zhang, please.
Yeah. Okay. So good afternoon, everyone. I'm Zhang Sihui, and coming from UIB in Beijing. So it's my honor to present our preliminary research findings based on a limited selection of cases with such distinguished scholars and practitioners. And I hope our work will contribute meaningfully to our discussions, and looking forward to receiving your valuable feedbacks and insights. So the topic is assessment of the effectiveness of the UNIDROIT principles as governing law in litigation. And this study, this study explores the principles' role in international commercial law, focusing on their judicial acceptance and evolving significance. My presentation today will begin with a brief review of the UNIDROIT principles. As we all know, these principles serve as a key framework for governing international commercial transactions. They aim to provide clarity, flexibility, and fairness in contract law. However, their role as governing law in litigation has been met with challenges, largely due to traditional conflict of laws doctrines. Courts have often favored domestic laws, limiting the principle's direct application. So building on this, our research focuses on the practical applications and judicial precedents of these principles, using the UNILEX databases as a foundation. This comprehensive database provides us with insights into how these principles have been integrated and applied in real-world cases. We found that while their use in arbitration is widespread, their application in domestic courts remains sporadic. For instance, a Swiss court in 2004 recognized the UNIDROIT principles as governing law, emphasizing their coherence and balance. However, inconsistency persists, as seen in a 2022 decision by the French court, which rejected their application due to procedural constraints under the Roma Convention. These cases underscore both the adaptability of the principles and the discretion courts have in their application. When explicitly chosen, the principles are expected to apply, but this expectation does not always exclude domestic laws. When applied implicitly, judges often consider them within broader frameworks like the lex mutuaria. Additionally, we observe the recent legislative developments indicate progress. The 2015 Hague Principles mark a significant shift by explicitly recognizing non-state rules, including the UNIDROIT principles, as valid governing law options. Countries such as Australia and the US are exploring similar reforms, fostering greater harmonization across jurisdictions. However, challenges remain. Differences in the nature, origin, and the content of the Hague and the UNIDROIT principles create potential for ambiguities. Thus, aligning these frameworks within domestic systems will require coordinated efforts. Since analyzing these findings, we have reached some conclusions that we believe contribute to the ongoing discussion about the role of the UNIDROIT principles. First, while its role of the governing law in litigation countries, remains less prevalent compared to arbitration, it is still supported by several countries. And second, with a growing emphasis on party autonomy, the recognition of the UNIDROIT principles within domestic courts is expected to increase gradually. And third, to facilitate this transition, UNIDROIT should prioritize collaboration with domestic legal systems and enhance the applicability of soft law instruments through synergistic efforts with organizations like UNCITRAL. So in conclusion, our study is still in its early stage, and I hope it has shed some light on the topic, and thank you for your time and attention.
Thank you very much to both of you, actually, and to you in particular for your presentation. So I understand that this is a study that you are still undertaking because you are finding the empirical evidence of, if I understand well, of what you are presenting and how to turn this weakness into a strength in a way. So how the future could present a greater chance of this type of instrument to be used at a global level. So, and particularly with reference to courts, because that is your specific attention. And it is true that courts do refer to the principles, but not so much as the applicable law, as you say, more as a means, as many of the presenters means to interpret or national law, and sometimes just to support solutions that the judge would have taken anyway, but in order just to show that they are not only domestic solutions. So, but I have taken perhaps too much time in commenting on this, and so I would like to open the floor for additional comments or questions from the audience at large or from those around this table regarding the findings of this presentation, or more generally, the essays that have been presented. I think, Caterina, I understand that they will be available on the web in their longer form, which means that any issue that was not specifically addressed here can be read and perhaps also commented upon in our social media. But let me open the floor if there are any questions. I see that Caterina herself has raised her hand. Caterina.
Thank you very much, and thank you for this insightful presentation. Myself, what sparked my interest is that you mentioned the Hague Principles from 2015 that could boost the acceptance of UNIDROIT principles because they directly reference the principles, and they are mentioned as very recent adoption, but maybe you could give us also some other examples of international regional instruments that could support the implementation and adoption of UNIDROIT principles globally or regionally or on national levels from like the past several years. Thank you.
So this, I understand, was a question perhaps to Shui Chang. And
yes, exactly.
Okay, thank you. I understand your question, and during our research, we only find this instrument, and maybe in other instruments, there are some implicit provisions that indicate that we can use UNIDROIT principles, but and this one, the Hague principle, is the most clear and the most I think that it is the most important. So maybe this is the we use this example. Thank you.
Thank you very much. And on a different level, because it's a different level than your discussion, we do have mention of the UNIDROIT principles in other UNIDROIT instruments that have been developed later on, like the principles for reinsurance contracts and the project that was mentioned in the first presentation today by Anna on investment contracts. So this is another way the principles continue to live on in a way, even if it's not the same level of analysis that you are undertaking. Yes, Don?
I think there's another example in the Latin American system, which Zhang, Sihui might look at. I think they also contemplate the possibility of non-national law, and that's been understood to mean the Hague, the UPICC.
Perhaps not mentioned expressly then, but certainly in the interpretation of what is meant by international law. Okay, so perhaps this is also something you have already referred to, those legal systems that have opened up to the use of international instruments such as the UNIDROIT principles, even if they are not expressly mentioned, but perhaps this is also an interesting field of research for you, whether there is case law, for example, or things like that. So thank you so much. Now, I understand that we are really moving to the closing, and Caterina, I will give you the floor again because the panel has finished its work, with many thanks to all the presenters and many congratulations and also well wishes for your brilliant future careers. So my congratulations. And now, Caterina, I give you the floor back. Thank you.
Thank you, Anna. Thank you very much. Thank you, all the participants. It's been a brilliant discussion. And now it's finally my pleasure to pass the floor for the closing remarks to the Secretary General of UNIDROIT, Professor Ignacio Tirado.
Thank you, Caterina, and thank you all. I think perhaps what Professor Wallace was referring to is I know the title in Spanish, but it's known as the Mexico Convention on Applicable Law to Contracts, private international law applicable to international contracts, which allows expressly for the application of non-national laws to contracts, and this has been followed by Uruguay and forgot which other country in Latin America which have incorporated to their own national
Paraguay.
Paraguay, yeah, exactly. So I don't know if that's what you refer to, but I think that's a good example of Caterina's question, if in case it's helpful. It's organized by the Juridical Committee of the Organization of American States. That's the one. Right. So thank you all. It's been a fascinating discussion. We had the pleasure also and the privilege of having Professor Paulus with us, and as well as colleagues from other intergovernmental organizations, such as the European Law Institute and other organizations. Plus, I might be wrong, but I think we'll be able to give this discussion some further dissemination, because it's worth it indeed, the watch. So thanks for that. Thanks. I know Anna said it already, but I'd like to expressly remind the gratitude of the Institute to Professor Wallace and the International Law Institute, but to him personally, because he's been a personal donor and supporter of this essay competition. So not only giving us his presence, but also his money, if I may, in that. And that's not something that anyone should take for granted. So Professor Wallace, thank you so much for your support for our organization, which dates back many, many decades. So
not at all. I'm very happy to do it.
Most appreciated. Right, to the rest of you and to those who participated, who were almost 200, as I heard, and especially to the team that also read all the papers. I should say that I didn't have the pleasure of participating in the selection process, so I pay a tribute to those who did, and by hearing the presentations today, I was particularly taken by the breadth and the importance of what was said in such little space, really, because it's very difficult to say meaningful things when you have only a few pages to tell them. Because then on the one hand, especially if you are younger, you need to prove that what you're saying is not just your opinion, but you've documented yourself. That includes a lot of citing, and that, of course, takes away space from your own reasoning. So it's a little bit of a tug of war in terms of strategic planning of the paper. So thanks a lot for this. I personally think that for too long, papers have been too long normally, not in this competition, but generally in academia. So this is a welcome exercise. Perhaps we should enhance it a little bit more, enlarge the possibility of, give you a bit more space. But since I am not part of the team that reads all the documents, I don't think it's fair that I take that decision. I should say that you have all hit the right nails when it comes to analyzing some of the main points of the UNIDROIT principles in its 30th anniversary. You've identified very well the fact that it is unclear to what extent. So you've identified all the different purposes of the principles. But I'd like to underscore something which has already been mentioned by some of you, which is the difficulty of assessing the success of some of the functions of the principles. It's very difficult to know with sufficient evidence to what extent they are, and to prove something which we all know is there, but can't prove it, which is their informal use for the drafting of contracts, for the negotiations. Precisely Don's question before. In the northwest of Spain, there is an area, Galicia, which is Celtic land, and which was famous for its tales about witches. And Galicians say, they have an expression which say, I can't translate it because it's Galician actually, but it says something like, there are probably no witches, but there are. So this is exactly what happens here. We can't prove that it's being used, but we know it's being used, especially if you talk to academics and to students. You go to moot courts, you realize to what extent this is the case. But there are nevertheless a number of points where the principles are particularly important. And they are especially important from the standpoint of UNIDROIT, which is an organization which was created to harmonize law and to influence basically legislators. And it's the following. One of them is to what extent our principles have influenced the drafting of new contract laws and amended existing contract laws around the world. And just to mention a few, we are here talking about countries like France, Russia, China, the Baltic countries, Argentina. There are so many countries in the world that have been influenced in their amendments to their sometimes not so new codes, that by itself is precisely the type of thing we're aspiring to provide as a tool for the legal community. So the fact that the parties to an arbitration don't expressly choose the principles means very little to us, or at least doesn't mean that the principles are not sufficiently used, not at all, because they become national law, and by becoming national law, they become hugely influential. So that's the power of soft law. In a way, I'm trying to answer one of the presentations which saw little use in soft law. Soft law is super powerful these days, sometimes more than transnational than international hard law, because it's becoming increasingly difficult to see treaties being ratified or acceded to by countries. So it's through soft law that you can actually more efficiently harmonize these days than through hard law. I'm not really contradicting anything that was said. I'm just saying it's a soft law that becomes hard law, either through domestic law or through the interpretation of national laws. And this is the other point where our instrument is very, very important. You all know that, some of you identified it expressly, how the UNIDROIT principles are used by courts in many countries, not directly as applicable law, because they often have their own law, but mostly to underpin the legal reasoning of their own system. So in that sense, the principles are, if you will allow me the metaphor, a sort of new pair of glasses to read old laws. And this is particularly important in countries which have old civil codes, because civil codes are almost untouchable. So the legal interpreter puts on the glasses of the UPICC and reads their law with new eyes, with new renewed eyes. And that's, again, extremely important as an instrument for unification. So I think That's another element which is very important. Finally, by way of development, we are, in light of the decisions of our governing council, moving towards the application of the principles to specific sectors of the legal reality. So we know our winner devoted her essay to sustainability. We have now a project on investment contracts, which is the direct application of the principles on sustainability matters. So this is an ongoing project which has canvassed a lot of interest in by countries from all over the world. As Anna mentioned, we have already an outstanding work together with the University of Vienna, Frankfurt, and Zurich in the interpretation of the contract on reinsurance in the light of our principles, which has been extremely useful as well. And we might be considering for the future the sectorial application of the principles to other fields of the law. So that's where we're moving towards, using the principles for specific areas, making them even more bespoke and more useful. Last word then is just to say that this type of event and the participation of academics, consolidated, but also young and upcoming, is our favorite activity. UNIDROIT was created arguably as the first ever legal think tank in the context of the League of Nations almost 100 years ago. The countries would send to Rome their brightest legal academic minds to come here and think about new ways and think about new laws and new systems of international legal exchanges. This explains, if you look at our documents from the 1920s, early 1930s, before the war devastated the world, you see a lot of brilliant reflections on international sales of goods, but also on intellectual property, on arbitration. We are talking about the 1920s, by people the stature of Ernst Rabel and others. So we are at origin an academic institution. We've now developed into a pure, into a full legislative body, but this academic soul remains in us, and you, all of you, are the realization, the concrete realization of our academic spirit every year. So thank you so much for your effort. We are so grateful for it, and we hope that we will be able to stay in touch in the years to come. Thank you.
Thank you, Ignacio, for the
Thank
kind
you very
remarks.
much.
If
you,
I
Anna.
may,
Thank you.
just to commemorate this moment, may we take the photo all together? That will be just a screenshot, but it will be also further used for our social media, if you don't mind. So let it be 1, 2, and 3. Perfect. Thank you all. Thank you. And all the best for everyone.
Thank you,
very much.
Katerina, and
Bye.
thank you.
Thank you,
Bye-bye.
Anna. Thank you.
Bye-bye. Thank you.
Thank you,
Bye.
Professor Wallace. Bye.